Jeff, Attorney General Schneiderman has recently announced his Conviction Review Bureau, headed up by his first deputy, Harlan Levy. In announcing it, he expressed some limitations on his jurisdiction and started to delineate what would have to be done in order for him to get involved. Do you think the Attorney General has the jurisdictional ability to review wrongful convictions in a meaningful way, or do you think he's going to need special legislative authority to do it?
The Attorney General's program is inadequate. It will not serve to protect the public, members who have been wrongfully convicted and who need intervention. Many people who were familiar with the Attorney General's work when he was a senator were well aware of his introduction of anti-wrongful conviction reforms, and so in working for him, in voting for him, and hoping for him to win the office of Attorney General, we were hoping for more of the same from him if he was elected to that post, including which would be that unit which we're discussing today. As I mentioned a minute ago, I do not believe that the unit will be effective in undoing any wrongful convictions. First of all, there's no case submission process. There's no apparatus through which a defendant, his attorney, or a member of the general public can submit a case to the Attorney General's office to review. In his press release, the Attorney General stated that there were only 3 instances in which he said that his office could intervene in a case. One of them was that if the governor invited him to come into a case, so he had received jurisdiction that way. A second would be if the local district attorney contacted his office and basically said that they didn't have the resources to deal with the case, or they otherwise didn't want to deal with it. It would be by invitation. The third would be a hybrid in which the district attorney contacts him and asks for assistance, the difference being that they, in effect, would deputize whatever agents from his office, so that instead of the Attorney General having control, the control would be with the district attorney. It would just have the additional manpower. I can't imagine a single case absent an extraordinary amount of public pressure and outcry in which a district attorney, having wrongfully convicted an innocent defendant, obtained that conviction, defended it successfully on appeal, in a case in which either they know the defendant's innocent or they realize it's likely there possibly is prosecutorial or police misconduct involved, possibly a violation of constitutional rights and or other conduct which interfered with a fair trial, which goes to the matter of whether a verdict is reliable. That having gone through all of that work, that a district attorney would now invite an outside agency in to then intervene, review a case, and have authority over it, where the district attorney would in effect supplant, where the Attorney General would in effect supplant the district attorney. I don't think that that's going to happen under any scenario. You got into a little bit about the legal authority or lack thereof that the Attorney General claimed to have, and that was the crux of why he's announcing the limitations. There are 5 different ways in which he has the authority now under the law as is currently instituted to intervene in the case. The Martin Act, which provides that the Attorney General can intervene in cases in which the government is being defrauded of money. In a wrongful conviction case, the government is in effect being defrauded of money. You're spending money to wrongfully convict somebody, defend the appeals, the cost of incarceration, the compensation, which is going to come out on the other end, both through lawsuits seeking compensation under state law, as well as in federal 1983 actions. So in order to prevent wrongful convictions from dragging out as long as they often do, with the average length of wrongful incarceration being 13 years, he would have the authority to intervene and prevent the states and the municipalities from losing a large amount of money. So that's one aspect of it. Another legal avenue would be an ongoing violation of constitutional rights on the part of a defendant. Not federal constitutional rights, but instead constitutional rights under the New York State Constitution. A third method would be that he could do a non-jurisdictional investigation in which the jurisdiction of the case may be under the district attorney, but that's not to say that he can't send investigators into the field, investigate, and whatever exculpatory evidence is uncovered, that could be turned over to the defense. We see on a lesser level, there was a case in the Bronx where a prisoner wrote the federal government alleging they had been wrongfully convicted, and the federal agents went into field, did some investigation, uncovered exculpatory material, and informed the Bronx District Attorney of what their findings were. There's no reason why the Attorney General's office couldn't do something similar. A fourth method under which he could intervene would be in the form of filing a friend of the court brief. In a lot of the wrongful conviction cases, when we look back on them, there were many red flags along the way. Whether we're talking about circumstances under which a very questionable identification was obtained, circumstances under which confessions were obtained, whether a junk science was involved. There's many red flags which seem really clear to us in hindsight. Those same red flags are clear along the way for people who have law degrees or are otherwise familiar with the system. So having observed one of those red flags in a case and doing the appropriate review, there's no reason why the Attorney General could not enter the case as filing a friend of the court brief. Say, for example, a defendant has unearthed exculpatory evidence, and so he files a post-conviction motion seeking to overturn the conviction. And the local district attorney takes an unreasonable position. The Attorney General could file a friend of the court brief in behalf of the defendant. It's hard to imagine a case in which a court would rule against the defendant in that situation, whereas ordinarily, when it's a defendant against the district attorney, often the courts, whether you're talking the trial court, the 440 court, or the appellate process, they often rubber stamp deny appeals regardless of the merits. And so the Attorney General's entrance into the fray would be very significant. Lastly, the last avenue of review is that a case having come to the Attorney General's awareness in the first place, he could then go to the governor himself and ask to be given the authority to have jurisdiction over the case. There's nothing in the law that says that he cannot do so.
You make a good point, but doesn't Executive Law 63.3 clearly delineate the Attorney General's powers and preclude the Attorney General from becoming involved in criminal cases except only under specific conditions? And doesn't this come back to the origins of the state constitution, where there was a basic distrust in the centralizing criminal prosecutions in the Attorney General? Which again would lead to the question, isn't the best way to do this to go to the legislature to give the Attorney General new authority?
I think that if he went to the legislature and got another law, got them to pass another law which explicitly gave him the authority as opposed to relying on interpretation of the law, yes, that would be better than relying on interpretation of the law. That doesn't mean, however, I reject the idea that he is powerless in the interim.
Okay. On your question of his getting involved in cases by filing amicus brief or acting when he comes across something, as you are so well aware, the Attorney General is the state official who usually defends convictions in state court in federal proceedings, so that when a state prisoner files for habeas corpus relief under 2254, the Attorney General is representing the superintendent of the facility. Given what you know, when you've described about your case, where a meritorious claim on its face was opposed on pure procedural grounds, what is the likelihood that the Attorney General's new position on review bureaus shouldn't that spill over, is what I'm asking you, in their position and how they defend these things? If they see something wrong, isn't it their job to begin with to say, well, we need to review this, rather than saying, sorry, the man has a claim, but he's 4 days late?
It is the Attorney General's job to seek justice and to intervene. Given the mechanism of the Bureau, the limitations that the Attorney General said he's going to observe, I don't think it's likely he's going to intervene in any cases. That being said, we've already talked about ways in which he could.
Okay.
I think that he should. In federal, you are exactly correct that in federal proceedings, the Attorney General is representing the state. However, that they normally pass that to the local district attorney, and so that's who files the paperwork. There's nothing in the law that obligates him to pass the case to the district attorney. So he could retain, that's a sixth method by which he could retain jurisdiction, obtain jurisdiction, or otherwise enter the proceedings on behalf of justice. To me, it's unconscionable, and it defies common sense that the second highest law enforcement official in the state, second only to the governor, that there's an ongoing wrongful conviction case, he's powerless to do anything about it.
You mentioned that the Attorney General should get involved in a wrongful conviction at any time he becomes aware of it, and you specifically mentioned federal habeas corpus, for example, or state post-conviction proceedings. In many cases, the Attorney General is the state official who defends the state conviction, for example, on federal habeas corpus. Would this be a good place for the Attorney General to put into action his intentions stated on reviewing wrongful convictions?
In terms of the point about concerns about not wanting to centralize too much power in the Attorney General's office, and who has responsibility for what, the jurisdictional issue between the district attorney and the Attorney General's office, I want to make the following point. The district attorney has the initial obligation, but failure to do so is what warrants the backup, the secondary role to come in. Our government, both on the state level as well as on the federal level, is all about checks and balances, division of power. So I think that the Attorney General intervening in cases is not only essential for justice, but is consistent with that principle.
Is it your view that the Attorney General's proposed Conviction Review Bureau needs more to it? It has to be something more than an announced plan? Does it need to have some teeth in it in order to go forward and be effective?
In terms of the point about concerns about not wanting to centralize too much power in the Attorney General's office, and who has responsibility for what, the jurisdictional issue between the district attorney and the Attorney General's office, I want to make the following point. The district attorney has the initial obligation, but failure to do so is what warrants the backup, the secondary role to come in. Our government, both on the state level as well as on the federal level, is all about checks and balances, division of power. So I think that the Attorney General intervening in cases is not only essential for justice, but is consistent with that principle.
So what you appear to be saying is that it's not so much whether or not the Attorney General has the authority, it's how that authority is triggered, and whether that's under the existing executive law statute, or whether there should be another subsection added to 63.3 to deal with the wrongful conviction process.
I would be in support. I would do everything I could to see that such a measure get passed. I think it's essential that we have a proactive Attorney General. New York State, like really all the states across the country, we have a very serious wrongful conviction problem here in New York. There's 27 DNA-proven wrongful convictions. There's many other wrongful convictions that have been established as such through other evidence in New York State. Yet, not a single reform has been enacted by the legislature to prevent wrongful convictions, and it remains a very difficult task at undoing a wrongful conviction. And that's why I think that such an act would be essential, as well as the legislature passing reforms to address the known deficiencies in the justice system.
Jeff, let's go on another point about wrongful convictions and the genesis of a wrongful conviction. You went into some detail about how your investigation started merely because some students in your school suggested that you acted strangely. Let me ask you, when does the investigatory process in a case like yours come to the point of no return? Is it when a confession is finally achieved or coerced, or is it when we're ready to go to the grand jury? Where is the point of no return? When when does the criminal investigatory process reach the point of no return, so that no matter whether there's evidence that's being withheld or not disclosed, or false evidence being relied on, the prosecutor is going to overlook that and just go forward? When does that point happen?
It gets to the point of no return once the police become convinced of a suspect's guilt. It's at that point at which they will ignore all the evidence of innocence or the guilt of another party and solely look for evidence as to the suspect's guilt. That misconduct that can take place there could include coercing a false confession, assisting a misidentification by making suggestions, either deliberate or inadvertent cues or clues with respect to identification, coercing third-party witnesses to falsely incriminate a suspect. A common theme in many wrongful conviction cases involves the police threatening mothers with removal of their children. So it starts at the police level, but at any point they could turn back, but they often don't. Once they made an arrest, the case gets handed over to the district attorney, who has the authority to prosecute or not prosecute the case. He has the authority to hand the case, to review it, and hand the case back to the police and said, this is not a good case, go out, get some real evidence, and come back. But we very rarely see that happen. Instead, the prosecutor continues the pattern already started by the police of ignoring exculpatory evidence or of going forward to try to convict somebody despite flawed evidence. Sometimes misconduct originates on the level of a prosecutor themselves. Then from there, the next most responsible actor would be the judge. A judge is supposed to be not only ensuring that trials are fair, but as part of that, he controls the gateway, what evidence is allowed to be used. We see in many of the wrongful conviction cases that were caused by misidentification, the judge allowed that testimony in the courtroom. There's a legal hearing called a Wade hearing in which he's supposed to assess whether or not an identification is reliable or whether or not the conditions under which it was made were suggestive. In nearly all of the wrongful conviction cases caused by misidentification, there were significant height and weight discrepancies from descriptions of perpetrators versus the description of the defendant, and the conditions under which they're obtained are sometimes questionable, yet they admit the evidence into court. Similarly, in the confession case, the judge is supposed to be determining whether or not a confession's been voluntary, whether or not it's been, whether or not the defendant has been coerced. Well, in my case, I was driven out of jurisdiction. I was held for a long time, between 7 and 7.5 hours. By the police officer's own testimony, I was on the floor crying in a fetal position. There was a misuse and abuse of the polygraph. There was good cop, bad cop. I mean, what else did he need? I mean, but yet he admitted he allowed the statements to go forward into evidence. In many of the wrongful conviction cases that were caused by coerced false confessions, the so-called confessions were obtained under questionable circumstances. Very rarely do judges suppress confessions. So they allow that to go forward to the jury. The next most responsible party would be each level of the appellate court. Appellate courts often rubber stamp deny appeals regardless of what facts and what laws are involved. That's why two common elements in wrongful conviction cases are that often by the time a defendant has been exonerated, an average length of time excuse me, of 13 years has went by, and often the defendants have long since had their appeals exhausted. So I think at any stage it could be turned around. It's just the problem is once the train pulls out of the station, it's a speeding locomotive and almost nothing will stop it.
We discussed over the weekend, we had an entire panel on defending justice for the poor, for people that are represented by court-appointed lawyers. And during the course of your presentation, you talked about the fact that you had a conflicted lawyer. Did you raise that on your direct appeal? And how was it treated?
You are correct that, you know, my attorney, who was from the Legal Aid Society, he represented me, and the other youth who the prosecution was falsely claiming had this consensual sexual encounter with the victim that youth was represented by another member of his office, not the same attorney, but the same firm.
Thank
You're
you.
correct, absolutely, sure. The conflict of interest issue was not raised on appeal. Remember that when I was convicted, I was 17 years old, and I had no legal training. I hadn't been in law school. I didn't even have the grasp on the law that I do today. So I was relying on my attorneys to craft the legal arguments. Of course, I do research here and there, but I didn't understand that that was an issue for me to research, and hence I didn't suggest that it be raised, and the appellate attorney did not raise it on her own.
What part, in your estimation, did the role of your counsel, the conflict of your counsel, or the ineffectiveness of your counsel, what part did that play in the travesty that occurred in your case?
The role that my attorney played in the injustice that happened to me, it was an important role, because he was supposed to be there to defend me, and he didn't. And he basically left me exposed and defenseless.
We went to prison and you began to explore what your remedies might be. Did you work pro se, or did you have counsel?
Well, I was assigned an appellate attorney, but I also went to the law library and tried to familiarize myself with the law as best as I can. You know, thinking back just for a second, when you asked me about improving the system of public defense, I advocate for a statewide independent public defense commission. So there would be one system throughout the state, so you would have uniformity, you'd have centralization, quality control, promulgation of standards. There would be oversight. Attorneys who would have been found to have provided inadequate legal representation in one case would not continue to be employed as a public defender to do it again in another case. The commission, in promulgating standards, would remove some of the inherent unfairness in the current system the way that it is. For example, there would be a limitation of the caseload. There would be an even economic playing field between the district attorney's office and the public defender's office. The district attorney has almost unlimited resources, many ways to investigate cases, and is able to hire experts. The defense, on the other hand, often has to ask a judge to allocate discretionary funding for experts, as well as at times to request funding for investigators. Often those requests are denied by judges who feel pressure to keep the costs of trials down on the county. Equal pay to both sides is also another factor, so that the best legal talent doesn't go to one side or into private practice. And in addition, not only are the weaknesses in the system the way that I've just outlined, but then an additional aspect of it, as was touched on in the conference by other speakers, often the jurisdiction in which you're arrested will also impact the amount of resources that the public defender's office has. If you're, for example, if you're arrested in a more rural county, there'll be the disparity between the resources between the public defender's office and the prosecutor's office, and or the quality of representation that you receive as an indigent defendant, the gap will be that much more widened and pronounced.
You talked about your appeal in the second department. You were convicted in Westchester County, which is in the second judicial department, which is very, very large. I believe it's the largest appellate division of the 4 departments in New York. You raised specifically insufficiency in the weight of the evidence and actual innocence. And you demonstrated negative DNA clearly in your brief. How did the appellate division, by a 5-0 vote of the panel, overlook that, in your estimation?
Well, I think that there's a problem in general with appellate courts, not just the second department, but but other departments as well. There's nothing I've seen to suggest one department is necessarily better than the other. So, having said that, I think that there's a few problems that contribute. Firstly, I think that in general, appellate courts engage in a rubber stamp denial process. I don't believe that an honest evaluation of the merits of facts and legal arguments is going on in cases. Otherwise, how could you reconcile the result in my case, for example, where, as you point out, there's a negative DNA test, and I'm raising innocence in 3 different ways: legal sufficiency, weight of evidence, reasonable doubt. And not only do they reject those arguments, but then they also say that there's overwhelming evidence of guilt. So I don't think that you can engage in an honest evaluation of the merits of my case and come to that conclusion if you're an appellate division judge who's doing an honest review. I think that too often appellate courts come to see themselves as an extension of law enforcement whose job it is to keep the public safe by means of finding any way possible to turn down appeals. Another factor is that a lot of judges formally are prosecutors and they move up the ranks, so I think that's a factor. Certainly the volume of cases, a point you raised with me in your question, I think that that's a factor also. I think that that's what fuels the idea of let's just hurry up and get as many through the mill as we can. Let's finish as many as possible. I think that drives it. And then lastly, the conflict in the justice system between accuracy versus finality of conviction. There's that tension, and I think that there's an overbalance in seeking to maintain the finality of conviction. But as I see it, what good is a final result if that result is inaccurate? Instead, I think that a paradigm shift in thinking that should take place is that, look, we have a system that has flaws. We don't get it right all the time. We should view each case objectively and carefully on its own merits. And if at any point in the process, no matter how long a case is dragged out, we realize something's wrong, then by God, we got to step in and correct this injustice before it goes on any further.
Would that be as part of the existing state appellate process or as part of this new wrongful conviction bureau that's being discussed?
Exactly, but also within the federal system also. A state prisoner, as you know, can file in federal court the 2254 petition for writ of habeas corpus. You can appeal that, and you can also appeal to the United States Supreme Court. So those bodies don't get a free pass either.
In your case, Jeff, habeas corpus failed. And in specific, it failed on procedural grounds because you were 4 days late in filing. Habeas corpus, as you are probably very painfully aware, was completely revamped in 1996 under President Clinton. How do you think that habeas corpus should be treated now? Should we be going back to Congress to try to reinstate the broad provisions of the Great Writ that existed prior to the 1996 amendments?
I do. I think that we need to examine the way that the courts are deciding, currently ruling now, the hampering of rulings. We need to repeal the Anti-Terrorism Effective Death Penalty Act, which puts the time limit on it. That's the same piece of legislation that works in language of giving deference. To me, it's unconstitutional because the judicial body is supposed to be independent, and courts should just make judicial determinations, rule on things, as opposed to being deferential. One illogical thing that we see happening in the federal courts often as a result of the way things are now is that federal courts are upholding convictions even if they agree with the defendant's issues by saying that the state court determination to the contrary is not objectively unreasonable. Right. That's not justice. That's not justice to me.
And this again was as a result of the recent 1996 amendment of the habeas corpus law under Clinton.
Yes, it is. And another point that I want to make is that the proceduralism, proceduralism, exhorting that over substantive justice is not justice. For example, in my case, my paperwork arrived 4 days late, albeit with inaccurate information from the court clerk, which caused it. I mean, that alone should have made it a non-issue. but let's push past that and let's just say 4 days late. Okay, I don't think that the appropriate remedy to cause lawyers to get their paperwork filed on time and in conformity should be that if they fail to do so, that a defendant's claim is dismissed. I think that a fine on the part of the lawyers would be more appropriate as opposed to dismissing an appeal, because you're putting a procedure over the justice. You're saying that it doesn't matter anymore what the merits of the issues are. If someone has been wrongfully convicted or not, that conviction needs to be upheld because a lawyer broke a local rule.
Just going back to the state courts for a moment, Chief Judge Jonathan Lippman has recently announced a policy in his court to accept more cases, criminal cases, for review. And there have been some increases compared to some very low grants of appeal in the past 5 to 10 years. What is your view of the role of the Court of Appeals? Judge Lippman has also advocated reform of wrongful convictions. How do you think that he's doing in terms of addressing wrongful convictions within his own court?
Given that, as I mentioned earlier, that most defendants who have been wrongfully convicted, by the time they're exonerated, their appeals have been exhausted. As I see it, the answer is more review, not less. Therefore, I would do away with the procedural vehicle of applying for permission to appeal, and then if granted, then they'll review it. I think that they should review all of the cases and make substantive rulings on the issues. Mm-hmm. In terms of there are other questions about whether Chief Judge Lippman is doing enough. The answer is no. I go by the actions of officials and people more than the talk. Okay, I know that he's been really outspoken about wrongful convictions and his wanting to do more about it. That having been said, the majority of the defendants have had their appeals denied. Often, one denial along that process was the Court of Appeals, frequently not even being given permission to appeal the case to the conviction, being given permission to appeal their case to that court. I don't see the Court of Appeals stepping in and correcting wrongful conviction cases where there's confessions obtained under questionable circumstances, identifications that are questionable, prosecutorial misconduct that does not result in reversals, ineffective assistance of counsel being provided to defendants, and it's not being such a high bar to meet is often not even raised, much less the defendant winning on that. So when his court, which he's the chief judge of, when they start doing more things to correct injustices on issues in which he has control of, he'll have much more credibility with me on things in which he's trying to persuade other bodies. And in terms of the counter argument, well, he's just one judge, and in the end, whether he's a chief or not, he has one vote. Let me start seeing his name appear on dissents, at least.
You were prosecuted by Carl Vagari and then Jeannie Pirro and then her successor. And while Mr. Vagari retired after his leaving office, Ms. Pirro sought higher office. And your case generated a great deal of publicity for her. Do you think one of the solutions might be that a period of waiting be imposed on prosecutors who seek higher office? For example, before Attorney General Schneiderman can run for governor, 3 or maybe 5 years should pass so that there can be no question that the cases he prosecuted and the matters he handled in office weren't motivated politically, or for that matter, District Attorney Pirro or any other prosecutor?
I was prosecuted and convicted under Carl Vagari. He was a district attorney. Okay. Jeanine Pirro became the district attorney before my appeals ran out. Often in public statements, she tries to distance herself from my wrongful conviction by pointing out I was prosecuted under her predecessor. That does not excuse her for everything that happened to me in the appellate process. Again, I was raising issue of my innocence, the DNA, my Fifth Amendment rights. They knew what I was saying. They understood the language, and yet they still fought to preserve that conviction, even blocking attempts to get further DNA testing. There's no question that in many of the cases that she's prosecuted, including defending my conviction, yes, that was motivated by political ambitions. I think that there should be a waiting period. I don't see the role of the district attorney or the attorney general, that office being charged with justice. The mandate is to seek justice, not simply to win, not simply to get convictions. That means convicting people who are guilty without breaking the law and in a constitutional fashion, and that involves dismissing cases against people who are innocent that they come to learn of that. I think that there should be a waiting period of 5 years between one office and the next. If the applicant for the next political office was formerly a district attorney or attorney general, I think that we need that length of time in order for the politician not to seek to benefit off of the reputation of being this really tough on crime prosecutor in order to win the next office. Because when you conduct just your current office, which is supposed to be meeting justice, and you want to create that tough on crime image as a means to gaining the next office, you're going to go beyond the bounds of what's fair, proper, and just. It's inevitable.
Over the weekend, you talked about prosecutorial immunity and the whole series of Supreme Court cases going back to Imbler v. Packman, which basically give categorical immunity to prosecutors from being sued civilly for prosecutorial misconduct, including the most egregious conduct such as fabricating evidence. What needs to be done about prosecutorial immunity? And again, should we be going back to Congress to pass new laws addressing that?
I would advocate passage of legislation, both on a state level as well as on the federal level. I think that it's critical to repeal that immunity because it will have a deterrent effect. There will be a reason for the prosecutors to pause when engaged in misconduct. There currently is nothing. In terms of answering the argument for proponents of prosecutorial immunity from lawsuits, saying that it'll have a chilling effect, my counter argument to that would be no other aspect of law enforcement, not experts who work in conjunction with law enforcement, not police officers, neither of those professions have immunity, and they're not hindered from doing their job. If they don't want to be sued, they do one thing: they don't purposely assist in wrongfully convicting people. They don't break the law. They don't engage in misconduct or breaking or committing violations of constitutional rights.
Well, Jeff,
why should they be a special class of people simply because they choose to make their living as a prosecutor?
Jeff, thank you very much, not only for this interview, but for the weekend. You've given us a source of inspiration by your dedication to this cause and your willingness to invest yourself and your resources into it. Good luck in everything you're doing.